Okay, let's get started. My name is David Jones. I am Associate Counsel here at Texas Realtors. Welcome to the Texas Realtors Legal Webinar series. We hold these. We have about 6 planned for the year, so about every other month. And today we are going to be talking about commissions. I'm sure you have heard the phrase, the 3 most important words. Well, let's consider these the 3 second most important words. This is your money. This is what you're working so hard for. So we are going to spend the next hour or so discussing basically broker agent compensation from beginning to end of the transaction, including we'll get into what happens if there is a dispute towards the end. If you have a question, you can go ahead and type it in. I'm not making any promises. I will try to get to all of the questions. Sometimes questions can be sort of specific to real intricate transaction. Those types of questions would be better fielded by our legal hotline. But if you do have a question, feel free to ask. Someone says the mic keeps turning on and off. Okay, I will, if the mic issue continues to become a problem, let me know, and I will try and get a IT personnel up here to fix it. But everything seems to be working, so let's give it a few minutes. If you're still having problems hearing me, please go ahead and ask a question. Okay, someone says they can hear clearly. Okay, brief outline for today. Quick introduction about the topic. We will look at broker compensation in representation agreements, the listing agreements, buyer rep agreements, the cooperative compensation offered in MLS transactions and non-MLS transactions, as well as what happens when you get into a dispute with another realtor. Okay, broker compensation. Most people, when you talk about broker compensation, they know procuring costs. Procuring costs, obviously, it is an important factor, and we will get into procuring costs and what it means. But in actuality, there are multiple agreements that affect broker compensation. And we're going to get into the key concepts of each of these agreements. The agreements that we'll be discussing are the listing agreement, buyer rep agreement. We'll touch on the 1 to 4 family residential contract and other purchase and lease contracts, and we'll spend a good amount of time on the cooperative compensation. That would be the agreement between listing brokers and cooperating brokers for sharing of fees. Quick note here, there are no standard commissions in real estate brokerage. Antitrust laws, as you can see, forbid brokers from different firms joining together to fix commissions. Any commissions amounts that we will be discussing today are really just examples, but they, commissions are fully negotiable between brokers and their clients. One of the key things to understand to sort of get a broad understanding of how commissions work is to really think about the different agreements that are involved, okay, and what parties are part of those agreements. So you can see here the diagram, the red boxes there, those are the various agreements. Now we'll be using a typical residential transaction for this webinar. One where there's both a listing agent and a cooperating agent, buyer and seller. Okay, so you're going to have a listing agreement between the seller and the listing agent. You got a buyer rep agreement between the buyer and the buyer's agent. There's going to be a purchase or lease contract between buyer and the seller or landlord tenant. And finally, you're going to have the cooperative compensation between the listing agent and the buyer's agent. Understanding this diagram will go a long ways towards understanding why does a rule work the way that it works. If you understand this, a lot of times that will answer your questions. All right, let's start with the representation agreements, just some general guidelines. Number one, representation agreements should absolutely be in writing. Okay, listing agreements and buyer-tenant rep agreements. Now, there's no legal requirement to have a representation agreement in writing. You can form an agency relationship with your clients without it being in writing. However, there are several key benefits that you get from having written representation agreements. Number one, MLS rules are going to require authorization from the seller in order to submit a listing to the MLS. Number two, you need a signed written agreement to enforce your commission. Okay, it's almost like a little mini statute of frauds. You have to have something in writing and it has to be signed by that person if you want to take something to court. Number three, code of ethics prohibits interfering with exclusive client relationships. Okay, how do you form an exclusive client relationship? You sign an exclusive listing or an exclusive buyer rep agreement. Okay, this is going to come up later, especially with buyer side agents who choose not to have buyer rep agreements. Okay, you're losing out on a very strong way to enforce your commissions by not having signed buyer rep agreements. Fourth, the Code of Ethics requires agreements be in writing whenever possible. That's Article 9. More general guidelines. Whose representation agreement is it anyways? This is talking about between the broker and sponsored agents. It's actually a TREC rule. TREC requires that representation agreements, listing agreements, and other representation agreements be signed in the name of the broker. Okay? They're the broker's clients. The broker is the one who has rights to the client, and the broker is the one who has rights to the compensation from the deal, not the sales agent. What sponsored sales agents do is they then have another agreement directly with the broker that spells out the terms of their sponsorship. Okay, and within that agreement, it's going to deal with commissions and splitting of commissions. Okay, but the commission starts, it goes to the broker first, and then you have that agreement to share that compensation with sponsored agents. That agreement between sponsored agents and the broker, it can take different forms. The form that Texas Realtors offers, it is an independent contractor agreement. It's Form 2301. It is possible for brokers to use a different form. Okay, but the one that we offer is the ICA 2301. It's possible also for brokers to have employer-employee relationships. Okay, but today we will be discussing Texas Realtor forms and the way that our forms work. If you have a different form, you got your own, or you had an attorney draft one up, you're going to have to talk to your attorney about the terms of those agreements. Big question that we get is what happens when an agent leaves her broker? Okay, this is one of the more popular questions we get on the legal hotline. Okay, the answer is, it depends. I know that's kind of a sneaky lawyer answer, but That truly is the accurate answer. There is no controlling law about this. It is what has the sponsored agent and the broker agreed to. In the ICA, the sponsored agent is entitled to the commission when it is earned. If the commission is earned while the sponsorship is still intact, then the sponsored agent is entitled to it. However, there are other terms within the ICA that might reduce or even eliminate an agent's commission if they leave the broker before the compensation becomes payable, i.e. when the transaction closes. Okay, so you really got to take a look at your whatever agreement, the ICA or whatever agreement that a sponsored agent has with their broker. That's going to determine what happens to compensation, the agent's compensation, when they leave before the transaction is done. Okay, let's focus on the listing side. The listing agreement. Remember, these are all separate agreements, and you got to pay close attention to the parties and the terms of each agreement. Okay, in general, what does a listing agreement say? The broker is going to market the property, and the seller is going to pay the broker if the property sells, either through the efforts of the listing broker or through cooperation. It's an exclusive right to sell. The broker's compensation can be expressed as a percentage of the gross sales price, or it can be expressed as a definite fee. It could be a set dollar amount, or it could be a percentage. The key thing to remember in this agreement is that the seller is agreeing to pay the listing broker, okay? In the Texas Realtors residential listing agreement, exclusive right to sell, the seller is not agreeing to pay buyers directly. The seller is agreeing to pay their listing broker. And then within the terms of the listing agreement, the listing broker will then offer compensation to a cooperating broker. So it's really it's like a two-step process. Those are two different agreements. The agreement that the seller pays the broker, and then the agreement that the broker pays the cooperating broker, two different agreements. What the listing broker will eventually pay a cooperating broker, that is contained in the terms of the listing agreement, and it's negotiable. Okay, so listing the brokers have conversations with your seller about not only the listing broker's fee, but also what compensation the listing broker is then going to turn around and offer cooperating brokers. In order for the listing broker's fee to be entitled to that compensation, the commission has to be earned and payable, and those are in quotation. The listing agreement has specific definitions for both of those. What does it mean for a listing broker's commission to be earned? Three situations will trigger the listing broker's commission is earned. Seller agrees to sell the property. Okay, they enter into a contract. Or a ready, willing, and able buyer is procured. Or if the seller breaches the listing agreement. But you got to have both earned and payable. So when is the commission payable? When the transaction has closed and funded. If seller refuses to sell the property after the commission is earned. Okay, so if one of the first three happen, your commission's earned, and then if the seller just says, I'm not selling, your commission becomes payable. And the third, seller breaches the listing agreement. Okay, so if you notice, seller breaching the listing agreement is in both categories. So if seller breaches, the commission is automatically both earned and payable. There's also a protection period in the Texas Realtors exclusive right to sell listing agreement. The protection period is probably one of the more misunderstood provisions in the listing agreement. We get a ton of questions about it. it is a provision where it's possible that the listing broker's fee will still be paid even after the term of the listing agreement is up. Okay. If there's a prospective buyer, the listing agent sends a notice to the seller of prospective buyers whose attention was called to the property during the term of the listing. If after the listing, during the protection period, seller agrees to sell to one of those prospects, okay, the broker could be entitled to their commission, the same commission they would have earned upon closing of that transaction. Now, here's the key, and here's the one that causes some confusion. The protection period doesn't apply if the seller enters into a new exclusive listing agreement with a realtor, okay? The protection, remember what the basic deal is with the listing agreement. Listing agent will market the property if the property sells during the listing agreement, the broker gets paid, okay? The protection period doesn't protect against that basic deal, okay? After the listing agreement is up, the seller is free to try another agent, okay? If the seller does go with another agent, they say, hey, you gave it a good try, I want to try somebody else, then that somebody else, that next realtor, they're the one who now have the exclusive right to sell. They're the ones who get paid. What the protection period really protects against is, say you're at the end of your listing, there's, you got a buyer who's interested, the seller knows who the buyer is now because of your marketing efforts, and so the seller decides that they're just going to wait you out and contact the buyer on their own once your listing agreement is up and try and work a deal and think that they don't have to pay any commission. That's what the protection period protects against, okay? But it doesn't protect against if a seller decides to go to another realtor after your listing agreement is up. That's when your protection period stops, okay? Let's see, got a question. Okay, question is, sell something in another MLS area, the commission is reduced. Since we don't know what's in the MLS, how do we confirm what the seller agreed to, or if it is just the listing broker's practice to not pay? Okay, I will talk about that later on. So I will deal with MLS and non-MLS commissions in a moment. Okay, let's switch over to the buyer-tenant rep agreement. And this is Texas Realtors 1501, the residential. Okay, buyer-tenant rep agreement, here's the deal. The broker agrees to help the buyer find the property. If they find the property, buyer buys it, the buyer will pay their broker a commission. That's a key point. The buyer is agreeing to pay the broker. Okay, the terms of the Texas Realtors buyer-tenant rep agreement says that the buyer will attempt to first get their commission from the seller or listing broker side. Okay, but if they are unable to get it, or if they don't get the full amount that was agreed to, the buyer is still contractually obligated to pay the broker. Okay, so the buyer's rep gives the buyer's agent really two potential sources of their commission. The buyer first, or I'm sorry, the listing broker and the seller first, but if not, then the buyer is still contractually obligated to pay. I know some brokers, I've talked to other brokers and they say if they don't really go after the buyer for any shortfall, that's a business decision for you guys to make. But as far as the terms of the contract goes, the buyer is contractually obligated to pay their own broker the commission. Okay, key point there. Buyer-tenant rep also has earned and payable definitions. They're slightly different, but very similar. Okay, in order for the commission to be earned, the buyer-tenant enters into a contract to buy or lease. That's earned. Or if the buyer-tenant breaches the representation agreement, that's pretty much the same term as in the listing agreement. Commission is payable when the transaction closes. Now, transaction closing, obviously, in a sale, you know there's a closing. In a lease, closing is defined as signing, entering into the lease. So if it's a lease transaction, once the tenant enters into the lease, that is going to be both earned and payable. Earned for a sale transaction, earned and payable are split. It's earned when they enter the contract, it's payable when the transaction closes. Okay. Also payable, buyer-tenant breaches the sale or lease contract, or if the buyer-tenant breaches this representation agreement. Buyer rep agreement also has protection period. It works very similarly as the listing agreement, that the buyer's agent can give the buyer a list of properties that they identify during the buyer rep agreement. If the buyer purchases that property during the protection period and it successfully closes, that the buyer's agent would still get paid the commission they would have received. And again, same term. It doesn't apply if the buyer is under a new representation agreement for the same reasons. Okay? It really protects against you helping a buyer find a property and then just waiting out till the end of the buyer rep agreement and then going directly to the seller to try and buy it on their own and save themselves a commission. That's the protection. Okay, let's talk quickly about the compensation, broker compensation in the purchase, specifically the 1-4 family residential contract. If you notice on my little handy-dandy diagram here, these arrows represent which direction the commissions are flowing. Okay, so in the listing agreement, the commission is flowing from the seller to the listing agent. Buyer rep agreement, it's flowing from the buyer to the buyer's agent, and those arrows are green. If you notice, there's a red arrow from the buyer to the seller. There is money being exchanged, but it's not broker compensation. Broker compensation does not belong in the 1-4 family residential contract. Okay, that is a contract between a buyer and a seller only. The brokers are not parties to the 1-4 family contract. Okay, broker compensation is contained in other agreements outside of the 1-4 family contract. In fact, paragraph 8 of the 1-4 family contract specifically says all obligations of the parties for payment of broker fees are contained in separate written agreements. Okay, and whenever we tell people this, particularly on the legal hotline, they always ask, but what about page 9? Page 9, the broker information page, specifically has a little line where you put in broker compensation. Okay, here's the wording from page 9. Listing broker has agreed to pay other broker, that would be the cooperating broker, a X% of the total sales price when the listing broker's fee is received. Escrow agent is authorized and directed to pay other broker from listing broker's fee at closing. Okay, this is really just an authorization for the escrow agent, so that the escrow agent knows that they're going to take out of the listing broker's fee and give it directly to the cooperating broker. Okay, if you look closely, the first line says listing broker has agreed. That's past tense. The listing broker and cooperating broker have already agreed to this commission. This language in and of itself does not create a binding agreement between the brokers. The brokers do not sign this. It's for informational purposes for the escrow agent, for the title company. Okay, if there's a conflict, if the separate agreement between the brokers, and the most popular one is going to be the MLS commission, we will get into that in detail later, but the most popular separate agreement for broker compensation, that's going to control, that's going to be your binding agreement between brokers, not this little line on page 9. So if there's a conflict, if the MLS says 2% and the broker wrote in 3% and nobody caught it, okay, it's going to be whatever the other separate agreement was. So the MLS compensation would control over this line. Now, there are a few contracts that actually do have provisions for broker compensation within the contract itself. Okay, I specifically point out the 1-to-4, that's the most popular form, and we get questions about that all the time. The ones that actually have broker compensation within the contract itself, the Farmer Ranch contract, Form 1701, and the Texas Realtors commercial contracts. Okay, our commercial contracts, both for purchase and for lease, actually have within the contract terms that the brokers can negotiate, and there is a spot for the brokers to sign those provisions, and the brokers would then be bound by those. Okay, but that is not the case on page 9 of 1-to-4 family contract. Okay, let's jump up to the top, the cooperative compensation, okay, between the listing broker and the cooperating broker, the buyer's broker. Commissions offered on the MLS, as I stated before, are the most popular cooperative compensation out there. That's the one that you're going to find yourself in the most. If a property does not have that cooperative compensation from the MLS, then you're going to need some other written agreement between brokers, okay, to establish that listing broker to cooperating broker compensation. And we will go over a few of the agreements that Texas Realtors offers. Okay, the MLS. The MLS rules and policies, okay, when you agree to participate or be a subscriber to an MLS, you agree to comply with the rules and policies. The way that the rules and policies of the MLS work is they create binding agreements between brokers, okay, just by being a participant of the MLS. So when the MLS applies, you're not going to need a separate written agreement. The MLS rule states the compensation has to be either a percentage of the gross sales price or as a definite fee. Okay, that mirrors what the listing agreement required. Okay, the listing broker goes on the MLS, they input the listing, they put in the cooperative compensation that they had already discussed and agreed with their seller. And it's going to be their percentage or a definite fee. Here's a key point. Compensation being offered on the MLS by the listing broker, it's from the listing broker, it's not from the seller. Remember, two-step transaction there. Okay, listing broker and seller already entered into their agreement. They negotiated, they came to terms about what the listing broker is going to offer cooperating brokers, and that's what the listing broker puts on the MLS. And it is now the listing broker who is offering it, and it is the listing broker who is going to pay it. It is a broker-to-broker transaction, the MLS. Okay, I am sure you have heard this phrase before. You're going to hear it again. The offer that is put that is placed in the MLS is a blanket unilateral offer to compensate the cooperating broker. Okay, unilateral offer, we're talking basic contract law here. What do you need? You need offer and acceptance and consideration, but for today, we're talking about the offer and acceptance part. A unilateral offer is an offer that can only be accepted through performance. Okay, it's not like an offer where someone makes an offer, someone accepts, and now you got a contract, and now you perform afterwards. A unilateral offer can only be accepted by performance. Okay, it's like if you offered to say, hey, David, if you come by my house next weekend and paint my house, I'll pay you $5,000. And I say, I accept. I say, no. If you come by and paint my house this weekend, I'll pay you $5,000. That's a unilateral offer. I can't accept it just by saying accept. I have to go out and perform. So if I show up next weekend and paint your house, that's the acceptance. That's the binding contract. You owe me $5,000. Okay, that's what's going on with the MLS. When a listing broker inputs the commission, that is a unilateral offer. The cooperating broker can't just call up and say, I accept. The cooperating broker has to perform. In this scenario, performance means being the procuring cause of the sale. Okay? You have to, well, we'll get into the definition of procuring cause, but that's the performance. Okay? Cooperating broker has to bring their buyer, initiate the event that leads to a successful transaction. So now we got the offer is the MLS compensation that the listing broker put, and the acceptance is the cooperating broker's role as being the procuring cause. There's your binding agreement, okay? No need of any other written agreement after that. Procuring cause, what does procuring cause mean? You heard it a million times, here's 1,000,001. It is the uninterrupted series of causal events which results in the successful transaction. The definition for procuring cause, it's unfortunately, it's just one of those situations where you're really not going to get a set answer. Okay, people look at me and say, David, can you tell me what the definition of procuring cause? Sure, it's an uninterrupted series of causal events which result in a successful transaction. And then they look at me and say, okay, now can you explain what procuring cause is again? Procuring cause, there is no rule of thumb. There is no one defining factor that says what procuring cause is. You have to look at the totality of the circumstances of the whole transaction, okay, for procuring cause. It's like if you're standing in the middle of a forest, you can see a few trees around you, but you have no idea how big and beautiful the forest is. But if you get in the helicopter and you rise above it, now you can see the whole landscape. That's what you need to do with procuring costs, to figure out if a cooperating broker is the procuring cause, and if there's a dispute between two cooperating brokers, which one, you got to look at the whole landscape. Okay, there are several factors to look at. Okay, who first introduced the buyer to the property? How was it introduced? Was the series of events starting with the original introduction of the buyer to the property and ending with the sale? Was it hindered or interrupted? Or anyway, was there a break? Did another realtor get involved at some form? Okay. If there was a break, who caused it? Did the first agent not do their job, lost contact, didn't talk to the buyer for months, and then another broker stepped in, or did the other broker intrude for some reason. Okay? Did the second broker unnecessarily intervene or intrude into an existing relationship? Okay? All of these are questions that need to be posed and asked and answered to really get to procuring costs. Okay, here's a link to NAR's website. I don't have time for everybody to copy it down quite yet, but this is a worksheet that arbitration panel members will look at to sort of determine procuring cause, and it's got a bunch of questions that they need to consider. Okay, it's looking at the whole forest. Okay, the presentation it is being recorded and it will be up on our website and a PDF copy of the slide. So this afternoon you can check out our website and all this will be up. We get this question a lot as well, procuring cause versus agency, okay? Just because one broker might have a buyer's representation agreement does not necessarily mean that they are the procuring cause of the sale. The listing broker, the offer goes out to the procuring cause broker. Whoever the procuring cause broker is, that's who the listing broker pays, which may not necessarily be the broker that has a buyer's rep. If the buyer, for some reason, went to another broker and entered into a transaction and that other broker is the procuring cause, that's who the listing broker pays. Okay, the buyer's agent that has the buyer's rep, okay, that's the binding contract, but remember my little house diagram, that's a separate contract. We need the parties to that contract. The buyer's agent and the buyer are the one who has that contract. Okay, it's possible that the buyer breached the buyer's rep agreement. Okay, if a second agent came along and interfered with that relationship, you could have an ethical violation. Okay, interference is one of the factors that gets taken into account for procuring costs. But from the listing broker's point of view, they pay whoever is the procuring cause of the sale, not necessarily which broker had the buyer's rep. Okay, offers to compensate in the multiple listing service, the MLS, are unconditional. What does that mean? Don't put any conditions on the offer. Okay, you already have sort of the built-in condition, which is procuring costs. Okay, the cooperating broker has to be the procuring cause of the sale in order to be entitled to the compensation. That's it. The listing broker cannot add extra conditions. For example, listing broker is not permitted to state that they will give 30% to the buyer's agent, but only with the full price offer. Can't do that. Buyer's agent must accompany buyer on the first showing to receive the commission. Okay, can't do that. Introduction, the buyer's agent introducing the buyer to the property on the first showing, that is definitely a factor in procuring cause, but you can't make that one factor alone a condition on the commission. You got to look at the procuring cause as the totality of all the circumstances. So you can't add that one condition into the offer of compensation. Another one in the lease transaction, commission equal to 1 month's rent only with 12-month lease. Okay, these are impermissible conditions. Okay, if the cooperating broker is the procuring cause of the sale or lease, they are entitled to the full commission, and those impermissible conditions will essentially be wiped out. If there are disputes over this, we will get into commission disputes at the end. See the caution flag, sellers trying to set conditions. Watch out for that. Okay. If the property is going to be placed on the MLS, remember, broker-to-broker transaction, it is the listing broker who is offering the compensation, not the seller. The listing broker has to follow the rules of the MLS. So if a seller starts trying to set conditions on what they want to pay, it's time for a conversation. Remember, the seller's paying the listing broker puts a property on the MLS, the listing broker is the one offering compensation. Got a question, does the agreement between brokers for residential leases executed after MLS offer of compensation modify terms? Short answer is yes, it does. That you're about 5 or 6 slides ahead of me on that one, Terry. But yeah, there is a way to modify the compensation, and we will get to that in a couple of slides. Bonuses. Lots and lots of questions about bonuses. Bonuses are part of the blanket unilateral offer to compensate, okay? They are not different. They are not different rules, meaning no conditions, okay? If a bonus is offered and the cooperating broker is the procuring cause, they get the bonus. You can't have a bonus, full price offer, then a bonus. No conditions. Even if the bonus is, just written in agent remarks, that's still part of the unilateral offer of compensation. Here's a tricky one with these two seemingly conditions. $2,000 bonus if property closes within 30 days, or $2,000 bonus if offer received within 30 days. One of these is okay, one of them is not. One's a condition, one is not a condition. What's the difference? How about the first one? $2,000 bonus if property closes within 30 days. That is a condition that is not allowed. Okay, $2,000 bonus if offer received within 30 days. That's okay. Difference being is that we will get into this in a couple of slides, but the listing broker can change the compensation before an offer is submitted. Okay. So the $2,000 bonus, if offer received within 30 days, a listing broker can put a bonus up there, and if they don't get an offer within 30 days, they can take it down. Okay, and that's essentially what that language is saying. That the listing broker is saying, hey, I'm going to put up a bonus for the next 30 days. If I don't get an offer, I'm going to take it down. So that is permissible. Okay, the first one is not permissible because the offer is already received. There's already a contract in that one because they're talking about closing within 30 days. So if the buyer's broker is the procuring cause, you enter into a contract, that $2,000 bonus was up there when the offer was submitted. You can't have facts, the property closing within 30 days. That's after the fact, so you're trying to change the compensation after the offer has already been submitted and the contract has already been accepted. You can't do that. That would be a condition. Okay, so received within 30 days you can do, closing within 30 days you cannot do. Home builders, you got to take a look. We get this question a lot, especially with the condition of you have to accompany your buyer on the first showing, otherwise you don't get the commission. And we get agents saying, well, why can builders do it? Well, if a builder is not using a realtor and it's not listed on the MLS, then they're not subject to MLS rules. Okay, if your client wants a builder new home property, make sure you contact the builder and find out what what rules, what conditions they placed on you receiving your compensation. Okay, and that brings up a second point. Take care for listing agents if you're going to sign a listing agreement with a home builder, because they may very well be used to their own rules when they're the one paying the commission. But once they sign a listing agreement and now the listing broker puts the property on the MLS, and those MLS rules are going to kick in. Now it's the listing broker is the one who is offering to pay the fee to the cooperating broker. It is no longer the builder paying directly, so now the listing broker has to work within the confines of the MLS. So be careful there. Okay, modifying the MLS compensation. The listing broker sets the amount, okay? This is based off of the negotiation that the listing broker had with their seller in the listing agreement. Listing broker sets the amount, okay? The MLS is actually prohibited from setting rates of compensation. They can't tell you, how much to charge, what to offer. The listing broker can unilaterally, meaning by themselves without anybody else having to agree. Listing broker can only unilaterally change the offer before the offer to purchase comes in. Okay, once the offer to purchase that property comes in, that commission that was offered becomes essentially locked in. Okay, so a listing broker cannot have one compensation amount up there and then as soon as they get an offer, go on the MLS and start changing the compensation. Once the offer is submitted, whatever the compensation was on the MLS, once the transaction closes and the cooperating broker is the procuring cause, that's the commission that is paid. Okay, someone says they're having trouble hearing. Is that everyone? Can you guys hear me okay? Everyone, I can hear you. Okay, might be the person who can't hear might be on your end. You're good, another one. Yeah, check your speakers, check your volume. The other attendee seems to be hearing okay. After the offer has been submitted, it is still possible to change it, but now it's going to take an agreement between the listing broker and the cooperating broker. The agreement to change must be mutual and voluntary, okay? You can't force, you can't coerce, but yes, listing brokers and cooperating brokers can absolutely agree to change things from what the MLS stated, okay? Here's a couple of modifying the MLS compensation, some do's and don'ts. I wrote do's and don'ts, and then I put 3 examples up there, and then I realized that they're all don'ts. Basically, the do is that agreements to change the compensation need to be mutual and voluntary. Okay, some things that'll get you in trouble. Listing brokers can't reduce the commission because they just feel that the cooperating broker didn't do their fair share of the work. That's not the standard. It's not a sliding scale. If the cooperating broker is the procuring cause of the sale, they are entitled to the full compensation. Okay? Cooperating brokers don't dictate how much the listing broker must pay you. You can't waive your buyer's representation agreement around and say, this is how much you have to pay me, listing broker. The buyer's representation agreement is between the buyer's agent and the buyer. The listing broker didn't sign it and didn't agree to that. What the listing broker did was offered up compensation on the MLS. And that's what they are obligated to pay if the cooperating broker is procuring costs. Okay, remember, under the terms of the buyer's rep, if there's any shortfall, then the buyer is still obligated to pay. But buyer's rep cannot force the listing brokers to pay them what they want. They can negotiate it, but you can't force it. The agreement to change has to be mutual and voluntary. Finally, cooperating brokers. Don't coerce the listing broker into changing the commission by using the terms of an offer or refusing to submit an offer as leverage. That would be a violation, one, of fiduciary duty, and in Article 16 of the Code of Ethics. You know, if your buyer gives you an offer and you say, here, I want to buy this property, but they're not offering the compensation, listing broker's not offering the compensation that you want, you can't withhold that offer and try to force the listing broker to change it. That's not a voluntary agreement to modify the MLS compensation, okay? All right, separate written agreements. Oh, let me deal, before I get off of that, let me deal with the previous question. Let's say the question was, often when we sell something in another MLS area, the commission is reduced. Since we do not know what is in the MLS or the listing agreement, how do we confirm what the seller agreed to, or is it just the listing broker's practice to not pay non-MLS members the same? Okay, there's a lot in that question. Okay, one, there's no requirement that the listing broker has to disclose the terms of their listing agreement with the seller. Okay, that's between the listing broker and the seller. So they don't have to disclose what the total compensation is. As far as MLS versus non-MLS, the offer of compensation that a listing broker lists on the MLS is going out to other participants of that MLS. Okay, and all of those rules that we just talked about, if the cooperating broker is the procuring cause, they're entitled to that compensation. That compensation doesn't apply to non-MLS participants, okay? And a listing broker does not have to pay the same amount, okay? And so it is a negotiation. You're gonna have to give that listing broker a call and negotiate something, okay? And there are written agreements for that situation that we're gonna get into in just a second. So when will you need a separate written agreement for, remember, we're still talking about cooperative compensation from the listing broker to the cooperating broker. When will you need it? If the property is not listed on the MLS at all, okay? Like a for sale by owner property, a new property, home builder property, that's not on the MLS. Or in the situation we just discussed, when the cooperating broker is not a participant of the MLS where the property is listed, and commercial transactions. Commercial transactions typically are not going to be listed on the MLS, okay? So cooperating brokers, the commercial buyers brokers, give the listing broker a call and negotiate something, figure out what, if any, compensation is offered. It's not unusual for both, parties to handle their own broker compensation. Commercial, sort of a different world. Okay, we have several cooperative compensation agreements for our members to use. We call them commission registration agreements. First up is the registration agreement between broker and owner. Okay, that's form number 2401. This is one of the more versatile forms because it can be used if the broker is going to represent either the buyer side or the seller side. Okay. This one's especially useful in for sale by owner. So if the for sale by owner is going to agree to pay the buyer's broker, okay, this is the form to use. It could also be used by the broker representing that owner, maybe for just this one transaction without a whole listing agreement. You can use this one where not a listing broker, but the broker for the owner, and the owner is going to pay them. Okay. This one is between the broker and the owner of the property. Okay, another question. Hold on just 1 second. Okay, got a question about how to make sure buyer's agents earn their commission by doing basic services for the client, such as showing property, helping their own clients contract forms, facilitating. Again, I answered that question earlier. It's all about procuring costs. Okay, buyer's agents, the cooperating broker has to be the procuring cost for the entitlement of the commission, and you got to look at procuring costs. The total circumstances and look at all those factors. If the buyer's broker is not the procuring cause, then they're not entitled to any commission, okay? Okay, next, commission registration agreement. Registration agreement between brokers. Okay, this one is used when property's not listed on the MLS. Remember, you don't need one. If it's on the MLS, or if the cooperating broker is not a participant of the MLS where the property is listed. So if you're out of market, this is the one to use where the listing broker and the cooperating broker need some written agreement for sharing of commissions because it's not on the MLS, or cooperating broker is not a participant of the MLS where the property is listed. There are commercial versions of both of these forms. Finally, the agreement between brokers for residential lease. This is a specialized one, particularly for residential lease. The other two, registration agreement between broker and owner, or between brokers, they have provisions for either a sale or a lease for the cooperative compensation. But this one is particular. Our members requested this form, and it just has more terms that deal specifically with a residential lease transaction. Okay, these can be used to establish the compensation, first initially, but these can also be used to modify compensation. So if the MLS says one thing and the brokers have mutually and voluntarily agreed to change it, these forms can be used for that. So if these forms are signed after the fact, after MLS compensation was listed, and the buyer's broker, listing broker want to change it, you can use these forms for that. Okay, another question. What other steps can be taken to address high client rebate brokers giving out combination lock code or super keys and MLS board? That's a bit off topic. I would suggest you call the legal hotline. We can help you out with those types of questions. That's a little bit outside of the discussion today about our commissions. All right, finally, what happens when you don't get along? You see Lionel and Lucy up there. What happens when there is a dispute? You're fighting over a commission. First thing to point out, remember, you are a fiduciary, you have a fiduciary duty. Okay, you got to put your client's interests first. Okay, essentially, you got to agree to disagree over commissions. If your client is buyer or seller, if they're trying to sell this property or enter into a lease, and that's what their interest is, that's what you got to do. You can say fighting over and arguing over compensation after the fact. Agree to disagree, get the deal done, okay? Ways to settle disputes. Texas Realtors offers many different services. We offer ombudsman service, mediation, okay, and a full-on arbitration hearing. If you have a dispute, the Code of Ethics actually requires realtors to arbitrate disputes instead of running off to court, okay? We would much rather these disputes be handled sort of within the realtor family amongst your peers. They are familiar with the industry. They know these rules. We have panel members that are trained on procuring cause and what to look for and what to ask. So there are some situations where using Texas Realtors arbitration process is mandatory. Okay, you cannot go outside to the courts. Okay, that is between disputes between realtors with different firms. That's the one that pops up the most. So you might have two different cooperating brokers. One had a buyer's rep, but somehow, some way, another broker submitted the offer. And now they're both saying, I started with that client and you jumped in and you interfered. Who's right, who's wrong? That's got to go to arbitration. The Texas Realtors arbitration can also be used voluntarily. Okay, both parties can agree to use our process instead of taking it to court. Disputes with a non-realtor. Okay, disputes between a realtors in the same firm, or disputes between a broker and their sponsored agent. It's voluntary. You can use our process to settle your disputes, but it's not mandatory. Okay, what happens at an arbitration hearing? Basically, an arbitration hearing is there is a panel of realtors. And again, those other services that we offer, we do offer an arbitration hearing, but a lot of times disputes get settled with mediation. The mediator will give both parties a call and really just try and talk and discuss and get the parties to agree on their own. But if parties cannot agree and it goes all the way to a hearing, there will be a panel of other realtors, okay, who will, and it's almost like a little trial, and both sides come in, both sides who say, I'm the procuring cause, no, I am. They come in, they say everything that happens, and the hearing panel will determine who is the procuring cause and who has rights to the commission. The cost to request arbitration is $400 a side. At a hearing, the burden of proof is on the complainant, the person who filed the request for arbitration, who says, hey, I'm the procuring cause, I should have I'm entitled to the compensation. Okay, it's up to them to prove with evidence that they are in fact the procuring cause. Standard of proof, preponderance of evidence. Percentage-wise, most people think of it as like 51%. You got to prove at least, you got to tip the scale at least 51% to your side to show that you are the procuring cause. There is a time limit on when you can file them. They must be filed within 180 days after the closing of the transaction, or within 180 days after you learned of the facts of the dispute. Okay, sometimes you might not discover that your client that you have been working with and you had done all this work and you submitted an offer and it was rejected, and then your client says, oh, I'm changed my mind, I'm not going to buy. And then you let it go, and then months and months later you find out that client went and their cousin just got their real estate license, and their cousin basically copied your offer and wrote their offer and bought the same property. But you don't discover it until 7 months later. Okay, it's when you learn of the facts that you have 180 days to file. Okay. Okay, and my hour is up. Thank you for attending. I hope I answered enough questions. I'm sorry if I didn't get to all of the questions. And I hope you learned something. If you do have some lingering questions or I didn't get to your questions, we do have the legal hotline available. For those who haven't experienced it, there was a recent change. We have gone to what we call a live hotline, so you do not need to call and wait for a call back from an attorney. We have 3 attorneys who are sitting by their phones, and you will be directed straight to the next available attorney. So you can, sit on hold for a couple minutes. I think our average wait time is under a minute of people being on hold. So give it a try if you got any other questions, and that is all for now. Thank you.